If you're suing a municipality, they have a cap that changes with a COLA adjustment every year. So you need to establish in your claim whether you're an invitee or a licensee. But you can look for these negligence per se claims in these, like you mentioned, in slip and fall cases. So are there building codes or there local ordinances that were violated? And those are things you want to grab onto. You may know the BOCA code can apply, so there may be things that you can get. And you can also sometimes get punitive damages in those cases, or try to submit on punitive damages. Even if you end up not submitting to the jury, you present that evidence throughout the case, try to get evidence of that, and then the question at the end whether you get to go to the jury or not on that is different. So MAI 22.01 through 22.10 governs that, and that you're always going to have comparative fault in these cases, I think. So remember that to modify your instructions with 3701. So let's talk about handling the case. So we talk about, and I talk about in the prepared documents about the about this. So you want to meet with the client, you want to thoroughly interview them, I talk about what you want to ask them. You want to take the time to vet these cases and spend the time to get to know them, because the more you spend time getting into the details, and the devil's in the details about these cases, the better you are prepared to handle these cases. I can't tell you how many times you're in an interview, you think you got it all, you do that, and then the client makes a side comment or something like this, and you're like, whoa, I didn't know that, you have these other witnesses, or you got these witness cards. You know what, I forgot to ask you whether or not you had insurance, so that I know whether in an auto case. Or you know what, I forgot to, we had a guy in the other day, he slipped on his concrete, and he goes, oh, by the way, my other neighbors, I didn't know this, but after I got hurt, my neighbors came up and said they had slipped at this same place. Or you got to sit there. No, do you have any pictures? No, I don't. Oh, I have some on my phone. So you got to take the time in talking with these people to thoroughly, your clients, not these people, right? To thoroughly vet these things and get this. People will always have information on their phones, whether it's a picture and you get them to email it to you, whether it is whatever it is. So tell them you're going to investigate the case and pursue the case on their behalf. You're going to talk to them about your contingent fee arrangement, which I'm going to talk to you about in the ethics portion of this as well. And typically, we charge a third of what we get for people, right? Typically, 40% is charged in med mal, employment, sometimes product liability cases. I find that people talk, and so if you're going to try to get the extra 36% or 40% or something else from the guy in the auto case, 2 years down the road when he's talking to his buddy who went to Brown and Crouppen or someone else and they got a third, he may not like you down the road. He may not refer you those next cases. So think about that in deciding the referral rate you want to charge someone, is you want to be fair to them and you want them to send you that next case too. So you want to be fair in that. And the ethics rules say that you can charge varying fees for trial, for other things. You can. I've done different things over the years historically. Sometimes I've had if I try the case or I'm a month before trial, I charge extra, because that month before trial you're doing a lot of extra work. Sometimes people charge extra on appeal. Some of those are appropriate. So think about that. It's Rule 1.5E. And then whenever you do that and you charge that, you're going to have to, part of the rule is you have to give them a written settlement statement at the end of the case. And I have a sample fee agreement here. Two things in here, and I have a third and 40% for med mals. Two things that didn't make it in here is I put on my contracts, I put a phrase that says neither party will settle the case without the consent of the other, because I want to make sure that they understand that this is a two-way street. We're talking about that, and that's more for the client interview, because people don't understand how this works. Do you decide to settle the case? Do I decide to settle the case? How does that work? The other thing that's not in there, I'll talk about what's in there after I finish this thought, is that I say that the client authorizes me to sign the back of a settlement check and deposit it in my trust account. Because if you settle the case down the road and you get a check to Burger Law and to Joe Ott, then if you put on your contract, they give you a power of attorney to sign the back of the check. You can sign their name, you sign your name, you put it in a trust account, and then you distribute the money to them at the end of the case with the settlement statement. Perfectly fine, should be done, that's the way you do it. And I tell them that right away. I tell them that that's on there so that when I settle your case, I can sign the check and put it in my trust account, which is an account that I hold for all my clients, and then I'll distribute the money. I have this thing in there in my sample contract. I cap miscellaneous fees at 1% of the recovery so the client knows, because they're always a little trepidatious about what is in your fees and what your expenses. Are you trying to add to that contingency fee? Are you trying to rip me off a little bit? No, we're not. And I tell them, look, my expenses are only what I pay out of pocket. The checks that I pay out of pocket from me, that's the only expenses that I put in, and that is true. That is all I put in.